now in session.
Please be seated. We are here in our case Wednesday, CV16-0763 Massey versus First HC. Each side will have 20 minutes for argument. Appellant, you may reserve any portion of that time for rebuttal, but you have to keep track of your own time. Move a clock at the podium for that purpose. We're recording this argument, so in a couple of days you'll be able to see yourself on YouTube. Because we're recording it, please identify your client and yourself when you begin your argument. We've covered the case, we've discussed the facts and the law, so we're familiar with it. So when you begin your argument, please launch right into what you want us to know. Counsel, you may begin.
Good morning, Your Honors, and may it please the Court. Robert Schaefer on behalf of the appellant, First HC LLC. The job of a trial court overseeing a partition sale is not to sell the property for a good price or a fair price or something that represents full value based on the trial court's choice among competing appraisals. Rather, the job of a trial court is to sell the property in a manner that is commercially reasonable and that it will bring the best price possible. What courts of equity have historically recognized is that requires, at the bare minimum, two things: adequate notice of the sale and an opportunity for competing offers. The problem in this case is that those things didn't happen. The trial court got started off on the right foot by denying an early summary judgment motion that sought approval of an unsolicited sale offer and concluded that, no, we need to have a fair process for considering offers. It was even on the right track when it entered an order that appointed a real estate commissioner to sell the property and specifically stated in the order, and this is the standard order from the Superior Court in this type of a case, the subject real property shall be listed for sale in a commercially reasonable manner at the value estimated by the market analysis, or if applicable, at the appraised value. And then it goes on to discuss that what that means is listed on the multiple listing service and subject to higher offers. The court was still on the right track even after a request was made to consider an expedited consideration of an unsolicited offer, because the court ruled that it needed to set a hearing in order to determine and resolve the objections that my client had to the special commissioner's market appraisal or market analysis and the appraisal. And in fact, the order it issued in as late as May 18th stated that the purpose of the hearing will be to determine the conditions upon which the subject property will be marketed and sold, consistent with the court's prior minute entry. So up until that time, the court recognized that it was its obligation to market and sell the property, give adequate notice of the sale, and to list the property in a commercially reasonable manner. However, the trial court was then deceived into granting an expedited hearing.
Deceived is an interesting choice of words. Why do you say deceived?
Deceived because in the application that was made, the trial court was told that we now have an unsolicited offer from Seven Jones. Seven Jones has a 1031 exchange deadline, and if we don't get a decision on this offer within the next 60 days, the offer may go away. Counsel, Mr. Massey, also stated in his application that Seven Jones had represented, presumably to Mr. Massey, that if the property were put on the market, then he would withdraw his offer. So those two facts were presented, or two representations were made to the trial court. And on the morning of the hearing, Mr. Massey's counsel stated, before any evidence was presented, that, well, this transaction is not subject to a 1031 exchange. And Mr. Jones testified at the hearing that, in fact, Seven Jones had other properties that it could sell at a later time if it still wanted to do a 1031 exchange, and then there was no urgency to review this particular offer.
But the trial court found otherwise then.
The trial court determined to go ahead with the hearing.
So it wasn't, if there was deception, it was cured before the trial court made the decision to go ahead with the hearing.
Well, the trial court was aware of the full facts prior to, on the morning of the hearing.
Then there wasn't any deception. The trial court came out of ruling with which you disagree.
Well, I suppose we could argue over semantics, but the court agreed to set the expedited hearing prior to the revelation that there was no 1031 exchange.
You have the opportunity to advise the court of what it might not have otherwise known and to ask for the hearing to be either extended out or dismissed.
Yes, that argument was made the morning of the hearing.
So the court did have that information in front of them.
Absolutely.
And what's the standard of review that we apply to the trial court's findings?
Well, clearly erroneous as to findings, de novo as to legal conclusions, and overall, with respect to the approval of the sale, it would be an abuse of discretion. In this particular case, the trial court made an error of law, based its decision on an erroneous belief, and this is represented in conclusions of law 6 and 7 of the signed conclusions of law, drew the legal conclusion that it had no obligation to maximize the value of the property. Its only obligation under the statute was to appoint a real estate commissioner and sell the property, period. No obligation to maximize the value of the property. As a legal matter, that is wrong under a de novo review. And what we cited to the court was instance after instance after instance of courts of equity in many different contexts, the probate context, the bankruptcy context, and the partition context, where a court is charged with overseeing the sale of property. The court has an obligation to maximize the value of the property. Now, the question becomes, well, what does that mean? How do you maximize the value of the property? Can the trial court simply make a finding after an evidentiary hearing that this unsolicited offer is the best possible price? That's essentially what Mr. Massey is arguing to you on appeal.
Well, how are we to determine whether there would have been a better offer out there?
The answer is quite simple, and it is you market the property.
So the statute requires that the property be marketed?
Well, it is the statute combined with background principles of equity. The statute does not.
You keep saying equity. Is the court acting in equity, or is it acting pursuant to statutory authority in this case? And if it is an equity, a court of equity, which I'm not sure.
It's absolutely a court of equity, Your Honor.
What's your authority for that?
Well, the authority is we cited a number of cases in our briefs that said even though the procedures are governed by statute, this is an equitable remedy. Partition has always been an equitable remedy. And in Arizona, it's been codified. And so the general rule is unless the statute specifically trumps the common law, then the court continues to apply the common law. And here, the statute simply says that the trial court shall sell the property in the manner and time and after notice as the court directs.
Doesn't it say a commercially reasonable manner or something along those lines?
The statute doesn't say commercially reasonable manner. So the question is, where do we get that? Where do we get that commercially reasonable principle? And it's from equity. Courts have recognized that when you sell property belonging to another, you sell it as if it's your own. And so how would you want your property sold? Would you accept the first offer that comes in the door? Or would you market the property for a reasonable period of time in order to determine whether this is the best possible price?
Whether it's the best possible price is a question of fact, correct?
Ordinarily, it would be a question of fact. But in this particular context,
So what you're telling me, what you're telling us is that equity demands that the property always be marketed. That there can't be any unique circumstance where,
No.
where the offer that you're faced with is the best offer that you're going to get.
well, the general rule that we're asking the court to announce is that the same rule that other courts in other contexts have announced, which is that absent extenuating circumstances, the obligation of the court is to market the property, to give notice and allow an open market sale.
Hasn't the legislature, when they've wanted to require competitive bidding and public notice in other contexts, they've been able to so state? So why wouldn't we read the absence of such requirements here as compelling?
Well, because the Arizona Supreme Court and this court have both acknowledged in the past that the way you deal with a statute that partially comes into a field that's already occupied by equity is that there has to be a clear statement of the legislature's intent to overturn a pre-existing equitable rule. And we cited those cases in our reply brief. Here, the pre-existing equitable rule is a trial court has an obligation to sell property for the highest possible price. There's nothing in the statute that explicitly trumps that equitable rule. And therefore, what the court had an obligation to do here was to sell the property for the highest possible price. And let me just point out that sometimes we can lose the forest for the trees, but here, if you read all of the cases that we've cited, and even the cases that Mr. Massey cites, and I'm happy to specifically address some of those, what they say is, and these are cases that Mr. Massey cited in his brief. This is a case from West Virginia, 1987, recognizing that the court has an obligation to set aside a judicial sale. In that case, it was a judicial sale as opposed to a private sale. And this is the quote from the case, where it has affirmatively appeared that there has been some circumstance chilling the appearance or bidding of prospective bidders. And an Alabama case from 1982, the overriding objective is to sell the property so as to realize the best possible price, and noting that the sale was advertised in the paper several times. And then we also cited 2 bankruptcy court cases. This is the same context.
Didn't the court below, using its, whether it's statutory or equitable powers, find that this was the most advantageous sale, this was the best that we could do?
Well, that was a clearly erroneous finding, given the fact that the property was not marketed. Think about this. If you sell a piece of property to Mr. Blue for $100, but you don't ask all the other people over here whether they're willing to pay a higher price, how can you make a factual conclusion that you've sold the property for the best possible price?
Same way courts value all sorts of damages and everything else. You have experts, you have testimony, you weigh the knowledge that people who have familiarity with these types of property purchases and sales would do.
But it is impossible, logically impossible, to draw a factual conclusion that property is sold for the best price possible if you haven't tested the market.
So a court cannot, and you seem to be contradicting your earlier answer to me, that there can be no factual circumstance out there where a court could legitimately not put the property out for listing.
There could be circumstances where a court could properly exercise its discretion to dispense with notice in an open market sale. But this is not that case.
Well, I mean, the trial court specifically found that to be the case, and my question is, how can we find that to be an abuse of discretion?
It's an abuse of discretion because the underlying factual determination that there are no better possible offers out there simply cannot be upheld based on a finding by the judge without testing the market. And smarter people than me have thought about this, and we cited a Supreme Court case from 1999 where the court drew this exact conclusion. It was in the bankruptcy context. The question was a question of one of the parties had to demonstrate that it was paying top dollar. In other words, the best possible price for this asset. And the court said it would be necessary for old equity, the debtor, to demonstrate its payment of top dollar. But this it could not satisfactorily do when it would receive or retain its property under a plan giving it exclusive rights and in the absence of a competing plan of any sort. It says any determination that the price was top dollar would necessarily be made by a judge in bankruptcy court, whereas the best way to determine value is exposure to the market. So it concludes that, listen, a judge can't just make a finding that this is the best possible price when there's an easy avenue available to test that. It's to put the property on the market and see what happens.
But counsel, does it matter what the sale price of the property is at the number that, especially that the court approved, if your client was offered 9% of $18.3 million and turned it down?
Well, it matters to my client because my client believes that the market that it had, first of all, you have to recognize that a partition context is the government coming in and telling a private property owner it has to sell its property.
So this wasn't a question of value. This was about the ability of an individual not to be forced to sell the property.
No. We recognize that the law requires us to sell. But it also says when we do, we're going to make sure that we get you the best possible price.
So when an $18.3 million number was asserted that your client would get 9% of rather than the lower sales price, your client still said no.
Well, that
sounds to me,
that,
wait a minute. It sounds to me more like you're saying, I don't want it sold, as opposed to, I disagree with the price.
Well, first of all, that's irrelevant to the question before the court.
Pretty relevant to me right now.
Well,
if you're going to say that all that mattered here was to get top dollar, your client was entitled to 9% based on their 9% holding, and they turned down 9% of $18.3 million.
They
The number
didn't.
that you guys asserted
They didn't
was the
accept
higher
the offer
value.
for the one day that the offer was open. The offer was made on September the 8th. It wasn't accepted, and then it was withdrawn on September the 9th.
Was your, I don't mean to be flippant when I say this, was there nobody in town that could have run that offer past your client and found out if they agreed to it?
I'm hesitant to discuss attorney-client privilege communications.
Well, and I'm not asking you to discuss attorney-client privilege. Let's just say that the question was asked. How's that?
Well, and let me try to argue it this way, that the fact that a private offer was made that would have increased the amount that my client would accept does not excuse the rule that says there's an obligation to obtain the highest possible price.
So
the
you're
court,
on
this
principle.
is the court's obligation.
This
not
isn't
the
a matter of
party's.
law. This is a question of principle.
I'm not sure I follow.
All your client was entitled to was 9% of 18.3, which was the top dollar, I believe, that you guys were asking for. So they offered to
No,
pay that.
there was a $23 million offer made on this property
The
before
question wasn't
this.
actually finished yet. That offer, 9% of 18.3 was million dollars was offered, and that was unacceptable based on principle.
The answer to that question is no. That's not the reason why the offer was turned down.
But they did turn down 9%, which was all they would have been entitled to of any sale price, of 18.3 million.
The offer was not accepted for the one day that it was
Not
open.
accepted. Thank you.
I will reserve the balance of my time, Your Honor.
Thank you,
Thank you.
Good chance. Counsel?
Good morning. May it please the court. My name is Hank Pearson from the law firm of Lake and Cobb, and our firm represents Leonard Massey in this matter. This case really is about fairness. It's about whether or not the Superior Court judge or this court can decide there was any error into ordering a valuable piece of property sold for fair market value after giving notice for nearly a year to the 9% minority owner the sale was the likely outcome, holding an evidentiary hearing, finding as a matter of fact based on evidence in the record that this was a fair market value sale, and ordering the property sold to the fair market value
Not the real
buyer.
question, because your premise is that the Superior Court ordered it sold at fair market value.
Right.
But our evidence of that, wouldn't the best evidence of that be putting it out there on the market and letting competitive bid?
It's a form of evidence, Your Honor, but think about selling a house. When you sell a house, What does the buyer focus on? He focuses on market comps. What does the lender focus on? He focuses on appraisals. What does the seller list the price on based on market comps? Those are the things that we dealt with at our evidentiary hearing in this case. We had the special commissioner, who is a commercial real estate broker, tell us before we had an offer that what his opinion of the value of the property was, which was less than $12,500,000. He went and got an appraisal who did not know anything about this offer, who independently determined his opinion of the value was $11,300,000. And then the court had a hearing and listened to the evidence and said, okay, what evidence do we have before us? And yes, marketing is a form of evidence, but this property had been known to the market before. We had had other offers even before the Seven Jones offer. There were 2 offers made by there was a furniture store that made an offer to us during the course of the litigation after the special commissioner was appointed. They weren't as good, and neither party was interested in them. They were
Counsel,
rejected.
your opponent just mentioned a $23 million offer. Is that in the record somewhere below?
Not that I'm aware of, and it wouldn't have been during this litigation. This property has been on and off the market for 10, 12 years probably. There was a prior partition action in another case number 10 years ago, and there was an offer that was accepted in that case, and then, of course, the market crashed and it never completed. And when this litigation was filed, we had asked the court to approve a $17 million offer. The stipulations and conditions on that offer were that the property be rezoned, that they didn't have any money, hard money in, they had a right to pull out all the way up to the end, even after rezoning. And as a matter of fact, that they ultimately canceled the escrow and walked away from the offer. So the court didn't approve it. It just kept going, and eventually the buyer just walked away.
Was there, did the parties, I assume the parties argued over whether it should be marketed, and was there any, I mean, why did the trial court determine that sending or that listing the property would not bring in more money?
There was no evidence at the hearing. I mean, the evidence at the hearing was the special commissioner said, this is the best offer. We should take this offer. This is time to take. I recommend you take this offer. I don't think we're going to do better. The appraiser from the special commissioner that hired Mr. Clemson testified the value is 11.3, so we're now $1.2 million over fair market value according to the appraisal. This evidence is in the record. It's not objected to, and the trial court can rest its ruling on that evidence. It may be conflicting evidence that, hey, someone else says it's worth 18.36, but the trial judge is the person who weighs that evidence and then in his discretion determines, based on that evidence, is there any reason to go farther? I asked the appraiser that First HC hired, I said, if we did more things to the property, if we rezoned it, if we did further work on it, would we get more money? He said, you may not. So he had a very equivocal position, so really, there isn't any evidence in the record that would suggest doing more, marketing more, is going to get you a better position or a better offer. And the special commissioner's position was, no, we should take this offer. And that,
how do you respond to your opponent's request that we establish or recognize a rule that in these types of actions there needs to be some, under equitable powers or equitable doctrine, needs to be some actual evidence of marketing and competitive bidding and fair market value? All
that equity would require is that they be treated fairly. And, the Arizona courts have spoken on this. The case of Crossman versus Meek is, in fact, a case of partition. And in that case, the party came forward and said, I think that the value is inadequate. The court did not do well enough. And the appellate court agreed on that case. But the appellate court said, and it talked about it, said, look, and this is at 27 Arizona App 477 for the site. It said, we see this as similar to an execution sale. So the general rule in Arizona dealing with the vacation of execution sales because of inadequate bids is that mere inadequacy of price, where the parties stand on equal footing and no confidential relationship exists between them, is not in and of itself sufficient to authorize vacation of the sale unless the inadequacy is so gross as to be proof of fraud or shock the conscience of the court. Well, here, and I cite other cases that talk about courts often approve, because this is a forced sale situation, courts will often approve sales that are at 50% of appraised value and less than that. Here we've got solid evidence in the record that we're actually beating a fair market value. So there's nothing to shock the conscience of the court. So there is a standard. Arizona says, look, we're not going to get involved in overruling the trial court's discretion unless it's just so bad that it shocks our conscience or it looks like fraud. And there's just no evidence of that in this case. We got a fair market value offer based on the evidence in the record. Marketing the property further, it's really simply a matter of speculation. There's no evidence that marketing is going to get us a better offer. It may not. We'll lose the offer we get. That's the trial judge's discretion. That's where the trial judge has to look at it and say, okay, the 91% owner is telling me he wants to sell it. The special commissioner says this offer is a good offer. We ought to take it. And the appraisal supports the offer. And I've given them a chance to give me contrary evidence, and I just don't accept the evidence. There's no room in this court to get in behind that and try to overrule the court's discretion unless it's just an abuse, which is the shock the conscience standard. So, here, this has been fairly done. This has been a fair proceeding. They talk about, hey, we were misled, that we misled the court by saying this is a 1031 exchange, and it's not. The contract clearly says this is can be a 1031 exchange, and the seller has a duty to cooperate with the buyer to expedite and get this sold so they can meet their 1031 exchange deadlines. So we had the obligation of the contract to come to the court and say we need to hurry. They're trying to do a 1031 exchange. As it appears, I have a feeling that's probably not going to happen. The trial judge was aware of that fact. But aside from that fact, if you look at the court's own order from January 14th, 2016, when he appointed the commissioner, he said, if there's an offer and it's denied, or one side doesn't want to accept the offer, if the special commissioner receives a written offer to purchase the subject real property, which the parties or either of them reject, the special commissioner may petition the court for an emergency or accelerated hearing and for acceptance of the offer. And that's exactly what has happened. The court told us that's what you do. Special commissioner sent up an application for expedited hearing. I filed a brief behind it saying we should have an expedited hearing. The court granted that after a very lengthy hearing on May 31, 2016, at which he told First HC, he said, if you don't want this sale to go through, here's what I need to see from you. Here's the evidence I want you to bring me. If you want it to be divided, I want you to bring me evidence of why everybody will be treated fairly and the property will be worth more if we divide it as opposed to sell it. If you think I need to do more marketing or if I need to do more procedures like rezone or those things, bring me evidence, bring me experts who will tell me that so I can hear your argument. I'm not foreclosing you in any way, but you've got to bring evidence to the hearing. And it didn't happen. And the whole nature of the expedited hearing, as it turned out, he granted the application on May 31. He had set a hearing early in July. He got sick. And the hearing didn't happen until August 17th. The original evidentiary hearing that was going to occur to determine what to do with the property was set for September 9th, 2016, before we got the contract. So we actually accelerated by 23 days. So while aspirationally we want to get the highest price possible according to the various cases cited, many of the same cases they cite say the same things my cases say, which is highest price possible can be far less than fair market value because of the nature of the type of sale that we have. We've actually achieved fair market value based on the evidence found at the hearing. Therefore, we have achieved everything that the case law requires and far more than the case law in Arizona requires. This does not shock the conscience in any way, shape, or form. If you look at it, if we had to market the property before the offer could be accepted, imagine how that happens. First, the testimony at the hearing, Seven Jones said, look, we became aware of the property. We figured out who the registered owner was, and because my client owns the lion's share of it, those people always end up calling him. We made contact, and we made an offer. We would literally have to say, that's great, that sounds like a really neat offer, but we can't take that until we put the property in the market and then come back and make an offer after we put it on the MLS. It's kind of an absurd position that leads us into this form over function. Excuse me. The whole point of the evidentiary hearing is to make sure that the ultimate offer is fair, that nobody is being disposed of their property in a way that shocks the conscience or is unfair. And that's why we have that evidentiary hearing. And they were given a notice of what they needed to bring. They were given the opportunity to bring that evidence to the court. And the trial court evaluated the evidence and found it wanting. And at the end of the day, that really should end the matter. If you look at the statute, since both parties agree the property should be sold, you first look at ARS 1218B, which says, if on the trial of the merits, on trial of the action, it appears to the court that fair partition of the property cannot be made without depreciating the value thereof, or that for any reason a sale is more beneficial to the parties or any of them, it shall in the first instance enter a judgment directing that the real property be sold. And then you move on to 1218C that says the court shall appoint a commissioner, it did that, to make the sale provided by subsection B and return the proceeds into court to be divided between the parties, persons entitled thereto according to their respective interests. We're waiting to do that because we haven't got it sold yet. Such commissioner shall sell the property in the time and manner and after notice as directed by the court. So the court has the discretion to determine what is the proper time and the proper manner. The court could decide, I think we should auction, we should market, we should do private sale. That's up to the court according to the statute. That gives the court enormous amounts of discretion. There's nothing in the statute that says that should be sold this way but no other way. So, you know, at the end of the day, you're trying to capture the reality that sales can come from any number of different possibilities, and the trial court then evaluates it through the use of the special commissioner and other evidence to try to figure out whether or not this is in fact an appropriate time and manner to sell the property. And he made that decision, and it is supported by evidence. At that point in time, even, Judge, if you would have done it differently, I don't think you can get behind the trial court's decision given the discretion that he has. I want to spend some time talking about the attorney's fee award. As the court has entered an order saying it will award attorney's fees to the Masseys, it has not in any way, shape, or form done so at this point in time. And First HC is complaining about that and saying, you know, this is an error. The trial court doesn't have the authority to do it. If you look at the trial court's order, the trial court gave us all warning up front, and as Mr. Schaffer said, this is a standard order. It's used throughout the Superior Court for partition actions. And it says in paragraph 9, the court shall impose sanctions against the party having unreasonably withheld approval of sale. And it says in paragraph 13, the court may impose additional sanctions for a party's unreasonable behavior under this order, and other sanctions may include contempt and award of attorney's fees or removal from the premises. The trial court has inherent power to sanction for unreasonable conduct. There's cases to that effect. If you look, Green Acres Trust, London versus Green Acres Trust at 159 Arizona 136 says, awarding attorney's fees as punishment for bad faith has always been available to courts. The trial court's award of attorney's fees is within its discretion. Here, the trial court has expressed enormous frustration with First HC throughout the case. First HC started defending the case by saying the property should be divided and it shouldn't be sold, and questioned whether or not the trial court had the power to order the property sold. On May 31, 2016, over a year after the lawsuit was filed, the trial court asked what evidence has been disclosed by First HC that the property should be divided, and he said, none. I haven't disclosed any, Your Honor. I'm going to try to develop that. And the court said, how can you file a lawsuit and take the position the property should be divided without any evidence? Then they show up at the hearing, and at the hearing they say the property should be sold, but it should be sold for more money, and it should be sold for $18,360,000, as Judge Jones pointed out. So they take a completely different position. Then the trial court orders, I think it was September 3rd, 2016, orally says, I'm going to sell the property to Seven Jones. Give me competing findings of fact and conclusions of law and sale order, and I'll decide which one to sign. And then we get a sale order back from them with findings of fact that say, sell it to us. Delay for 60 days while we go look for financing, and then if we can find financing, sell it to us. New position, not in the record, not brought up at the evidentiary hearing, more delay. And the trial court says on the record at one point, says, Mr. Schaffer, I know what you're doing. You're trying to create a record after the fact. I told you I would consider evidence of the record at the hearing and nothing else, and I don't appreciate what you're doing. Ultimately, these types of behaviors got to the point where the trial court said, look, it seems to me you just don't want to sell the property. And he was very frustrated, and based on that, I think he found that there was unreasonable conduct and that he's going to make an award of attorney's fees. But we don't know how much. And since he's got discretion to do it, whether the discretion is abused or not really depends on what he does, what his ultimate reasoning is, and how much he gives. And we just don't know. So I think this appeal is premature, but if the court is inclined to say, does he have the power, I think it's clear that he does have the power underneath the existing case law, and in the fact that everybody was given notice that this could come. Nobody should be surprised by what happened here. Judge, although I've got some time left, I've really covered the things I wanted to say, and I really don't want to just stand here and waste your time any further, so I'm going to go ahead and sit down unless one of you's got any further questions for me that you want me to clarify.
No, thank you.
Okay, thank you so much.
Counsel?
Thank you, Your Honor. Robert Schaefer on behalf of the appellant. This is not a single-family home. In that context, it's typical to get an appraisal, and if a first offer comes in for the appraised amount, you sell it for that, because a bank is only going to lend the buyer the amount of money necessary to buy the property at the appraised value. This is a 56-acre piece of raw land that is subject to wildly varying opinions of value. Their appraiser came in at $11 million. Our appraiser testified that it was at least $18.3 million. And he also criticized this appraisal because it was based 3 of the 5 comparable properties were bank-owned properties that had sold more than 3 years earlier. Did my appraiser have comparable properties at the higher level? No, he didn't, because there weren't any sales during this interim period of time. What he showed was that between the bottom of the recession and 2016, when this hearing was held, even though there haven't been a lot of sales in the interim, the property is increasing in value. The argument was then made to the trial court, Judge, you should accept this offer, it's a good offer. Our objection was, it may be a good offer if you just accept that the value of the property is $11.3 million. But why not test the market?
And
What is the reason not to test the market?
that just seems like a factual issue that the trial court gets to decide.
Yeah, but let's look at what were the reasons the trial court gave for not testing the market. The only reason the trial court gave, there were 2. One was legal and one was factual. The legal one was, it's not my obligation to get you the best possible price. He was wrong about that. It is the trial court's obligation to get the best possible price. The factual conclusion was, well, I have a real estate commissioner telling me that this is probably the best offer we're going to get. First of all, that is absolutely not what the real estate commissioner said at the hearing. What he said at the hearing, when he was pressed on cross-examination, you got to look at both sides, he said, this is probably the best offer we're going to get in this short of time. Well, in a year earlier, in May of 2015, Mr. Massey sought approval of an offer that was for $17 million. My client objected to it, saying, well, there's been no analysis done. Nobody knows if this is what the property is worth. There was a $23 million offer that was made and accepted and fell through because of the recession.
Is that in the record anywhere?
I'm sure it is, Your Honor, but I just can't put my finger on where it would be at this point. I think it was testified to at the August 17th hearing. So the question the court should be asking is not, did my client come forward with evidence that there was definitely going to be a better offer? How would we prove that? The question should have been, Judge, is there a good reason not to market the property? And the judge identified nothing, no good reason not to put the property on the market for at least a reasonable period of time to see whether there were higher offers.
And so your time is up. Thank you very much for your arguments today. We'll take the matter under advisement and issue a decision in due course. We stand adjourned.